Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everybody. My name is Lisa, and I'm one of the lawyers at SpringLaw, and joining me today is Eveline Hellinga. Welcome to nearly the end of 2022. I'm wearing my party shirt because it's almost the end of 2022, and we're pretty excited about this. As most of you know, we are employment and contracts lawyer and employment lawyers, criminal law in the workplace, at our virtual law firm based out of Ontario. For those who are new, welcome to our webinars. Feel free to ask any questions throughout in the chat function to keep it interactive. We are happy to answer questions as we go along. Download the slides from the handouts tab in the platform. And finally, if you would like any information about our law firm, please feel free to visit our website at springlaw.ca, where we have a bunch of resources there, including our award-winning weekly blog posts, a link to subscribe to our monthly newsletter, and an information about our innovative subscription program for employers and our DIY legal products, including our fairly new Boss Law Bootcamp. Okay, so Eveline and I are presenting. Before we start, though, even as a virtual law firm, we do acknowledge that we all work throughout Ontario on the traditional territory of many nations, and that this territory is now home to many diverse First Nations, Inuit, and Métis people. As lawyers, we must have a disclaimer in place. This is all legal information, not legal advice. It's not a lawyer's talk without some sort of disclaimer. Here's the juicy details if you would like to read more about the disclaimer. And let's move into today's presentation. So we're going to talk about hot topics for 2023 while reviewing and talking about 2022. So we're going to talk about the new era workforce, employment contract updates, the 2023 policy checklist, and the post-pandemic workplace. So thankfully, we don't need to only talk about COVID, but we will talk about a little bit of the post-pandemic issues. So I'm going to talk about topic number 1, and then I will hand it over to Eveline to really dig into topic 2 and 3. Okay, so the new era workforce. There is a labor shortage and lots of ink being spilled on quiet quitting. So for much of 2022, we saw employers really struggle to try and find and retain employees, especially in certain industries. 2022 saw this big trend of quiet quitting. And if you're on TikTok, it felt like 110% of the workplace was somehow quiet quitting. The idea is that after the grind and the uncertainty and the taking it for the team pandemic workplace, employees really began to refuse to go above and beyond and in their workplace. So there's different points of view on this. On the one hand, on the one end of the spectrum, we have employees who, and again, if you're on TikTok, you saw all these videos refusing to do all this undefined, intangible, vague expectations 24/7. At the other end of the spectrum, we have employers who are frustrated with employees who are refusing to work, who are failing to take their career seriously, etc. Somewhere in the middle is the reality, but quiet quitting really brought this all to fruition. So why? Certainly, we've all been doing this existential navel gazing and reflecting on our lives, our relationships, our workplaces as the whole world upended itself. If you think about it, our workplace infrastructure was established in the 18th and 19th century in the Industrial Revolution. Before that, we were all, working from home on our little farms around the world. And overnight in 2020, everything was challenged, and all knowledge workers and beyond were sent home because of technology and the reality of the pandemic. So people started questioning, why put up with these horrible long commutes, for crappy jobs and crappy Canadian weather, and never see our kids before dark, and just really questioning our workplace. So this is really philosophically what was leading to quiet quitting, plus burnout. The intense impact of all this uncertainty, the isolation, and the stress of the global pandemic, let alone the practical realities of health and some of the divisive politics that were going on. Everyone's burnt out. According to one of the studies that we were looking at, 35% of the workforce has reported experiencing some level of burnout, and 1 in 4 say that it significantly impacts their mental health. And I would be surprised if it wasn't actually a little bit higher than that. There's different levels of burnout and stress, and a report is a report, who knows? But what we're observing from employers is across the board. Everyone is struggling. The Great Resignation is another one of these big trends that we've been living with over the last couple of years, and this got a lot of attention given the labor shortage. It was partly a way to explain why it is that we couldn't find. We hear this from employers all the time. Where is everybody? Why can't we find workers? In 2021, apparently almost 48 million employees left their job. They quit, hoping for higher pay, more benefits, and better career options. Many people also just started their own business in the massively expanding online economy. Ask any of your kids how much millions of dollars these 20-year-old YouTubers make. There's online courses, ebooks, all these things that didn't exist even 5 years ago, let alone the metaverse and all the alternative ways to make money now. By August 2022, however, this summer, the U.S. workforce grew back to its pre-pandemic size and started to expand beyond. And then as of last month in Ontario, our unemployment rate was between 4% and 8%. So there has been this great resignation, but I think we're at a tipping point where it's not really, people who want to work are working. Okay, so that's the big picture background. So what are some tips for managing in this era of quiet quitting? Employees have leverage, and this, the ebbs and flows, but right now employees have leverage. I do think we're at a bit of a tipping point, but in the meanwhile, some of the biggest gripes or concerns that we hear from employees that we represent, or employers who are talking about feedback from their own workplace, clarity on what are after hours expectations. This is, especially for the new remote workforce, and this was a big problem during the pandemic. More clarity on what is expected after hours. Take a look at your meetings and your one-on-ones. Are they meaningful? Are they preventing focused work? Is there a ton of pinging on all the different new chat channels that have really great benefits on the one hand, but with setting expectations about how quickly people need to be responding? Is it okay to just tell everyone, I'm going around the moon and I'm going to focus? Clarity on what is work and what are optional extracurricular activities. We're heading into holiday season, or we are in holiday season, and we're seeing the shift from before the pandemic of pulling people out of their day-to-day life and going to these great big after-hour events. Is that work? Is it not work? Is it, traditionally it was considered a real perk. Many employees are thinking it's actually just a big pain in the neck to like not hang out with their friends and family and have to do a great big work thing. But it's a matter of asking employees what's going on. Keep in mind the impact of inflation. Very steep inflation happening right now. That's definitely, if you haven't given some raises, people are not making what they did last year. Making work more meaningful as opposed to just perky and fun. I think that perception a couple of years ago of putting in the ping pong table in your workplace and your beautiful brick-lined open concept is the way to go. It's shifted. People are after time at this point. Most importantly, just ask your employees. So when in terms of managing your employees in a quiet quitting universe, employers still can set down expectations and require employees to meet those expectations. The same performance improvement plans, written expectations, clear expectations of timelines, all of these things haven't changed at all. Progressive discipline is still a thing, and termination is still a thing. So, employees have leverage, but employers still have all their tools. Just lastly, before we move on to the next topic, the other trend we're hearing about is quitter's remorse and boomerang employees. So we are hearing less panic from employers about having no employees available. So I think the tide is turning. This really employee-friendly market is starting to decline as we head into 2023. We're starting to see all kinds of layoffs in the tech sector. And so you're starting to see articles on this about quitter's remorse and this idea that all these employees who left their job for no other job now can't find that golden goose that they were expecting. And so we're starting to see some come back to past employers saying, you know what, I've had my time to take a look and I'd like to come back. So those are the boomerang employees. We've actually had a couple of clients speak to us about this. And do you take them back? Do you not take them back? From a legal point of view, from an HR point of view, if they're an awesome performer and you have a labor shortage, why not? If they were just looking for more pay, why not, right? Especially if you're looking for work. If they were a pain in the neck employee in the first place and a bit of a complainer, you might not want to take them back. And so employers are starting to have some choices again. Legally, keep in mind that if there is a short gap between employment from when they left and when they're back, courts will likely, over a period of time, start to collapse that into one length of service. So, that may impact down the road the size of a termination package that you need to give. And if you did already give them a termination package, you'll need to just think through those logistics of, okay, they're coming back. I don't want them to have this double payment for the time they've already been paid out for. So just capture that in plain English language in a new contract so that you're not doubling up on an exit payment down the road. But do keep in mind that ESA severance will capture all the time. So that there's some specific language in the ESA around severance. So you'll just need to keep in mind on that. Burnout, mental health, and workplace accommodations are still one of the busiest areas for us and really the most difficult, especially as we're starting to head into a downturn and some companies are looking to eliminate headcount, needing to be mindful of those who've recently taken leaves or expressed disability issues. Anyone on this call has likely handled this in some capacity over the last while. It continues to be a really high-risk area. The legal obligations under the Human Rights Code remain. You have to accommodate any disability up to undue hardship. It's for our small employers where the owners and the managers are just as stressed and burnt out as everybody else. It's a tough area. There's no one size fits all. So in the interest of time, we'll go to the next topic. But, as communal therapy, this is a really challenging area and probably one of the areas where it's, we have no DIY products on this. This is really customized legal advice to figure out what is the individualized approach on this one. And finally, over to Eveline.
Thanks, Lisa. So I will be talking about employment contracts, which I'm sure has been a challenge for many employers on the call over the past couple of years because we've seen quite significant legal developments since 2020, specifically with respect to termination clauses. So I'm sure many of you have already dealt with this and updated your employment contracts as a result of the 2020 decision, Waxdale, that came out from the Ontario Court of Appeal, where the court found that an unenforceable just cause termination clause made the entire termination clause unenforceable. So that really turned a lot of employment contracts on their head and required employers to sort of take a look at their contracts and clean it up. We've seen a lot of challenges with terminations resulting from the Waxdale decision since then, and have advised on quite a few contract updates as a result. So just as a reminder, termination clauses are really valuable, or can be really valuable for employers, because it helps contain the most expensive part of your employment relationship, typically, which is termination. So since Waxdale, we've seen two decisions come out this year, one from the Ontario Court of Appeal and one from the Ontario Superior Court, which further sort of clarified the decision and continues to put a high burden on employers. And we wanted to share those with you today. So one of those decisions was Rothman and Canon Design, where the court looked at the fact that the employee was a sophisticated employee. She was a senior level employee. She'd received independent legal advice before signing her contract. And it was argued that the parties had the subjective intention to ensure that termination clauses were enforceable. But at the end of the day, the court said, well, a termination clause that tries to contract out of the ESA is still unenforceable. These other factors are not going to save you on that one. So something for employers to keep in mind. And similarly, on in the decision that came out called Henderson and Slavkin from the Ontario Superior Court, the court further sort of expanded what we saw in Waxdale, where they looked at a confidentiality clause and a non-compete clause in an agreement, which talked about just cause termination and referenced an employee's entitlements if they were to breach the confidentiality and non-compete clause, essentially wiping them out. And the court found that since those clauses appeared to contract out of the ESA, the entire termination provision in the agreement were also unenforceable. So these are all really important decisions, and a good reminder for employers to be very careful about how those termination clauses and any reference to terminations, and particularly just cause terminations in your agreements, are drafted, and also to check your agreements regularly, because the law continues to develop annually and sometimes faster.
Mm-hmm.
It is a high burden, for sure. So moving on to the next topic, we'll talk about policy goals for 2023. So recognizing that, employers only have so much time and you can't do it all, we thought we'd highlight a couple of policies that you'll want to have in force in your organization next year, and ones that you may want to update based on how 2022 has unfolded. So we've got two newly legislated policies in Ontario this year in 2022. That includes the right to disconnect and electronic monitoring policies. So these apply for employers who have 25 or more employees only. So if you're smaller than that, you're off the hook for now. If you happen to grow in 2023 or later and end up with 25 or more employees by January 1st of any future year, then you'll need to get those in place by March 1st of that year. And they're not terribly onerous policies, but they are required. Employers are required to have them. The right to disconnect simply needs to set out, expectations for employee communication and availability after hours. And the electronic monitoring policies needs to set out how and for what purpose you're electronically monitoring your employees. There's a few other requirements in terms of how they're rolled out and who needs to see them, etc. And you can take a look at our previous webinars and blog posts that we've written about both of those policies for more information. Other updates that you might want to consider for 2023 are remote working policies. So a lot of workplaces have changed over the past couple years, and particularly over the past year. And so if your remote working policy, if either you don't have one and you have workers now who are working remotely, or you have one but it doesn't reflect how employees are working, maybe you've moved to a hybrid or back in person arrangement, you'll want to take a look at that and update it. We've also got updates to vaccine policies as public health measures continue to change. You'll want to take a look at that and see if that needs to be updated. And similarly, to reflect your remote or hybrid work environment, if that's changed, you'll want to take a look at your workplace harassment and violence policies and your health and safety related policies to make sure that they apply to the way that your employees are working now. Back over to you, Lisa.
Thank you. Yeah, and especially the complaint process will look different if you have a hybrid or or all remote workforce, and what that all looks like. To what extent are things going to be on a video? If you have these workplace harassment and violence policies that are 5 or 6 years old, I'm sure it will look quite different than how you would actually functionally do it now. And we're in a world where video is fine for all these things. On to topic 4 around the post-pandemic workplace. But before we go there was a question that came in about what would be, so here's the question: what would be classified as a short time for this boomerang employee issue? What is a short time between coming back to an employer? We had a 9-year employee leave and return after 4 months. So it will depend, I'm sorry to say. If they were to leave after 1 month, then it might not make that big of an issue. But if they now stay another year or 2 or 10 years, then in the big picture, the 4-month gap is going to be irrelevant, and they're going to have this full length of service that will date back to the beginning of the 9 years. So I would say, even if there was 9 years and then a 4-month gap, it's likely that 4 months will get captured within the overall length of service, for sure within a year or 2, if not sooner. Okay, the post-pandemic return to the office. So there's 3 main issues around the post-pandemic return, the post-pandemic workplace generally. So the first issue is around these vaccine policies. We're finally seeing some commentary on whether or not mandatory vaccination policies are okay, but they're mostly in the labor context. We still aren't seeing much court action on this, and if so, it's a little bit mixed. So, labor arbitration cases are very helpful, but they're not binding on a non-unionized workplace. So, typically, the labor arbitrations have generally accepted that mandatory vaccination policies are reasonable, although many have found that any discipline or especially termination for failure to vaccinate is unreasonable. The response that is typically required or suggested is just put them on a leave, and then when all this mess gets sorted out, they come back, as opposed to firing people for failing to meet the policy. We've cautioned people against doing that all along because it's such an unknown, unprecedented thing. So, and as it is now, it will continue to evolve, and I think it'll be surprise surprising to me in 2023 if it will continue to be considered reasonable not to be vaccinated. But that's, you know, it really will depend on the workplace, you know, are you in healthcare, etc. But so far, it's really been assessed on a case-by-case basis, depending on the workplace. Oh, and you know what? We have another question. Do you have any templates available for those policies? Why, yes, we do. And that wasn't even a planted question. We do have templates. If you go to our website, we have some, and go into our template store, we actually have some templates, especially the electronic monitoring and annotated policy that you can purchase for download. The next issue around the post-pandemic workplace is mandatory hybrid arrangements and whether or not we can start pulling people back to the workplace and require them to start coming in person. And we're seeing lots of varied opinions on this and whether or not people want to, do they have to, what does it look like, what day, you know, there's lots of different ways to do this. The hybrid model does remain popular, but it's actually tricky to roll out. So the big legal risk is if you have contractually promised to people, whether that's implied or in a piece of paper, have promised to people that their job is now remote and they don't ever have to return back. If you now require them to come in person, you're looking at a potential constructive dismissal claim from the employees. So if they're an employee who was hired during the pandemic, those are especially the high-risk ones because there might have been ambiguity or silence on whether or not they're ever going to come back. So if you are a workplace that really wants your people in person, make sure you put that in the contract that if, you know, whether it's temporary or that you really do want people back in place, physically in place. And finally, remote working. We're seeing lots of different options. I'm super excited about these digital nomad visas, and I keep looking at it and keep trying to talk my kids into quitting all their extracurriculars so we can move to Costa Rica. There's not much guidance from the courts yet on this, but a lot of these new arrangements are a reflection of people being able to work from anywhere because of digital universe we're in, and also different countries are setting up these nomad visas to deal with the tax implications and create more flexibility on all of this. So, you know, I think we're going to continue to see more and more employees looking for this option and figuring it out. There's always going to be this sort of trifecta of employment law standards, what applies and all the contract and statutory stuff around that, and then tax and immigration. So there's always going to be these three different areas to figure out with remote working when people are leaving the jurisdiction. Over to you, Eveline, to tell us what your 2023 predictions are.
Well, thanks, Lisa. So based on how 2021 has unfolded, we are expecting that employees will continue to have some leverage, but it looks like that is starting to decline, as Lisa discussed, with some of the recent trends in layoffs and just the way that the economy has been moving nearing the end of 2022. It looks like mental health will probably continue to be a core and difficult issue for many organizations to navigate. So as those public conversations about mental health continue and we continue to think about more sort of creative ways to address the challenges with burnout and mental health conditions, that is likely to continue to be at the center of many employers' workforce concerns. We also will see courts hopefully start to catch up on remote and hybrid issues, so that we'll have some more guidance on what the real risks and potential solutions to those risks might be with workers moving remotely, and as Lisa just discussed, perhaps moving outside of your province or the country and continuing to work for you. And I think we'll probably get some more guidance on non-competes and location-based constructive dismissals. And finally, termination clauses will continue to be attacked and set aside. We've seen this quite a lot, and expect to continue to see it quite a lot in 2023, but employers have the chance to catch up with the changes and developments in the law since 2022. So definitely check your contracts and have those reviewed if you haven't over the past year to give you a bit more stability in your workplace.
We had a couple of questions, and so we have time for one more, and I'll try and collapse a couple of them into one. So do you have examples of changes to include in a health and safety policy for a hybrid workplace? And then another person asked about what to include if it's a harassment and violence policy for remote workers. So kind of overlapped issues. So some examples for a health and safety policy when you have a remote or hybrid workplace are things like, if a person trips over a cord at home, is that a WSIB claim? And or is it, is there some sort of responsibility on the employee to have a safe workplace? And thinking that through, to some extent, trying to, as an employer, outline what that liability, who is liable for that, and who's responsible for, a workplace. You can have language, something like, you agree, employee, that that you will keep a safe workplace. It always feels overly lawyerly and kind of obnoxious. I know that, but giving some sort of due diligence comment in these policies to just flag the issue that people need to keep their workplaces safe. It's not going to prevent people from tripping over that cord, and so in real life, sometimes it doesn't matter. But from a legal point of view, it does help give you that due diligence, that you turned your mind to the issue. In terms of the harassment and violence policies, thinking through, back to the health and safety, the other piece around that is putting in your remote worker policies whether or not the employer is responsible for ergonomic equipment. If a person is sitting in their wooden kitchen chair and getting a bad back, is the employer going to buy everybody good chairs, or is it the employee's responsibility to ergonomically have a good workspace? So it's setting that out as well, in just putting some lines down. In terms of the complaint process for health and safety, I think that really is where, where do they email? What does the complaint process look like? Is it going to be by video? Setting out what the process looks like if you are in a remote environment. And then, as always, that any digital misconduct also counts. So the after hours, it used to be 10 years ago, people putting dumb things on other employees' Facebook post on their wall. I think we've kind of moved past some of that, but there's still harassment that happens through text, through digital means after hours. Is that captured? So making sure your remote work policy is, and your email civility, or whatever you call it, is also capturing these issues. Evelyn, did you have anything else to add to how the remote and hybrid workplace might impact these policies?
Not really. I think you've covered pretty well. I think one suggestion that we have made in the past for employers who really want to help ensure their employees have a safe work environment at home and really cover off those OSHA obligations would be to have some kind of checklist as part of your policy, which employees can use to, check their work environment regularly to avoid any unnecessary risks. So things, as Lisa said, like having cords lying around, making sure those are cleaned up, etc. You can have, you might want to have it as a separate document to your policy, but you could have regular check-ins on those things be a requirement for employees, just to, again, reflect that the fact that they're in a remote work environment, and really cover your OSHA obligations there.
Mm-hmm. Yeah, good point. Okay, we're at 11:04, so we better start wrapping up. Thank you, everybody, for coming to our webinar today. We will post this on our YouTube channel, and you can check out other videos that we've done there as well over the last year. We do this on the third Wednesday of every month, so there will be a good collection of other videos there for you to look at. Our next webinar, we're skipping January, will be on February 15 at 10:30 a.m. Eastern Standard. The topic is to be determined. I haven't plotted out 2023 yet, I admit. But in the meanwhile, feel free to join our newsletter to stay up to date and get the invitation for the free webinars. If you have any other questions, feel free to follow up with any of us. Here's our team listed here. And of course, head over to our website for any updates or follow us on social, Facebook, Twitter, LinkedIn, Instagram, TikTok, YouTube. Come and sign up. And thank you very much for joining today. We hope that you have a wonderful holiday.
Thanks, everyone.